The last-minute judge appointments by John Adams in 1801 resulted in a court case that caused the Supreme Court to gain a power that it still has today, the power of judicial review. The Supreme Court was established by Article 3 of the United States Constitution and began in the year 1789. The Supreme Court wasn't taken seriously. In the 2008 video titled Marbury v. Madison by Public Resource Org on YouTube, it was thought that a ruling by the Supreme Court could simply be ignored. The court case Marbury v. Madison gave the Supreme Court a power that was not provided in the U.S. Constitution. This power is the power of judicial review. The actions taken by John Adams when Thomas Jefferson won the election resulted in grievances that were taken to the Supreme Court. This caused the Supreme Court to grant itself the power of judicial review. First, I will talk about the history of the first elections. The first elections allowed presidents and vice presidents from different parties to win the election. The chronological list of presidents from the Library of Congress lists our presidents. Thomas Jefferson had been the vice president to John Adams. Jefferson was a Republican and Adams was a Federalist. Jefferson had lost the election and became vice president because the vice presidency went to the candidate that won second place. Those past disasters are no longer allowed to happen. Jefferson won the next election and he became the third president of the United States. This caused the Federalists to panic. Next, I will tell you about the panic that resulted after the third presidential election. John Adams lost re-election to his vice president, Thomas Jefferson. Adams wanted to keep as much power for his Federalist Party as possible. Britannica.com states that Adams enacted the Judiciary Act of 1801, which, according to the 1801 Judiciary Act page of American-Historama.org, it became law less than 3 weeks before the end of Adams's presidency. This 1801 Act cut one of the 6 Supreme Court judges and removed the Supreme Court's power to take court cases. It then created 16 new judge positions, 6 judicial circuit courts, and many court offices. Adams wrote appointments for all of the new judge positions consisting of Federalist Party members and his friends. American-Historama.org states that Adams appointed 16 Federalist Circuit Court judges and 42 Federalist justices. Britannica.com states that the appointments were approved by the Senate the day before Adams was to leave office. This meant that Adams had to write all of the 58 appointments and have them hand-delivered by the Secretary of State before noon the next day. Now, I have not been able to find anything about how the appointments were attempted to be delivered, but in 1801, the mode of transportation was horseback. The Library of Congress website says that cars weren't invented until 1886, and they weren't available in the United States until 1876. The Secretary of State, Marshall, was not successful at delivering even half of the appointment letters. Jefferson ordered the new Secretary of State to not deliver the remaining commissions when he took office as president. Lastly, I will speak about how the Supreme Court got out of handling the grievances that resulted from the appointments not being delivered. Marbury was appointed to be Justice of the Peace, but he was one of the appointees that did not receive his commission, so he took his case to the Supreme Court. Marbury requested that the Supreme Court issue a writ of mandamus. This is an order to compel lower courts to follow the law. The Supreme Court ruled that issuing a writ of mandamus to be unconstitutional. The power to make such a declaration is called judicial review. In summary, President John Adams had a vice president from an opposing party. The vice president, Thomas Jefferson, won the third presidency, and John John Adams failed to complete his appointments on his last day in office. The Supreme Court declared a writ of mandamus to be unconstitutional, thus giving itself the power of judicial review. The Supreme Court has much more power than it did when it was first established, and it has enacted its power of judicial review on many more occasions. The Supreme Court wasn't taken seriously by the executive branch at first, but now its decisions are final and it is the highest court in the land. Thank you.